Good evening, everyone. Welcome to Understanding Family Law. We're very excited tonight to have with us Paul McConnell from McConnell Family Law, and he's going to be explaining everything that we'll need to know, essentially about the difference between family law and why you would need that family lawyer as opposed to other types of law. So I'm looking forward to learning along with everyone else. So Paul, I'm going to have you take it away.
All right. Thank you, Rachel. All right. So I will share my screen so you do not need to look at me the whole time. And more importantly, I don't need to look at myself. All right. Is that working okay, Rachel?
Yep, just go to, yep, there we go.
All right. So thanks again. As Rachel said, Paul McConnell, McConnell Family Law Group. We have offices. We cover throughout the state, primarily from Hartford, and we also cover Fairfield County, but we can meet people in New Haven and Groton as well. It's myself and at least two other lawyers, sometimes three. And as we were chatting beforehand, we, aside from the offices, we do so much by Zoom nowadays, at the client's discretion. We're happy to meet in person, but a lot of times people can meet via Zoom, which is 90% of the time we do for initial consultations. Most of what I'm going to be talking about today is really what we put forth in our initial consultation, particularly vis-a-vis divorce. I'd like to start off with something a little light, a true story. As you can tell from this first slide, as well as the next slide, I have a background in the military. I was in the Marine Corps for many years, and I was stationed at Camp Lejeune, North Carolina. And I don't know if you've ever heard of Krispy Kreme donuts. I know around here Dunkin's really popular, and who doesn't love Dunkin' Donuts? But down there, North Carolina is the home of Krispy Kreme donuts, and they're so delicious. They just melt in your mouth. But as a Marine, I needed to stay in shape, right? So it's kind of a battle of discipline. And when I drive into work every day, I had to pass by this Krispy Kreme, very busy, wonderful establishment. And every day, so day after day, I was disciplined, going by, I got to stay in shape, be disciplined Marine. But one time, I was thinking to myself, and some temptation was getting to me, and so I prayed. And I said, dear God, I'm just going to pull into the parking lot here. And if I'm going to drive, and if I see that there's an open parking space, I'm going to take that as a message from you that I'm allowed to go in and have a Krispy Kreme donut. And after 3 trips around the parking lot, wouldn't you know it? Anyway, it's a long-winded way of saying, I hope you find what you're looking for here today. We're going to cover a lot of stuff. Family law, when you hear firms market themselves as family law, mostly we're talking about stuff related to divorce, custody, children. There are some firms that do some more stuff than that, but usually if you see a firm that says family law, that's what we're talking about. Most of the time they don't do other things that help families, like real estate, wills and estate planning or probate. Most of the time, if you see a firm like ours that markets for family law, we don't do those things. Now, we know a lot of people that do, and we're happy to refer people to great attorneys that we know that cover all those practice areas. But that's just as an FYI. So normally we're talking about divorce, custody, children, and the like. And we're going to dive into some of those topics today, kind of an overview 101 again, the type of stuff we cover in initial consultation. And by the way, while I'm talking about initial consultations, the public is conditioned to think that initial consultations with lawyers are always free. And that's because the personal injury attorneys spend millions and millions of dollars, even in just Connecticut, millions and millions a month. And they condition the market, free consultation. Criminal defense lawyers, which I was once upon a time, also often do free consultations. Some family law lawyers do, to be sure. It's been my experience from knowing my colleagues, most do not. Most of the time we charge for initial consultations. In family law, same thing with estate planning for the most part. Again, there's exceptions, but that's just something to know. And then I've also seen a trend recently where there's a few firms that now marketing that they offer free initial consultations in family law, but you don't actually meet with an attorney. You meet with staff member or paralegal who's really there just to make a sale. So buyer beware. Okay, what we're going to talk about today, order march, is kind of what we'll talk about, different pathways to the same destination. I'll talk more about that in a few seconds. How long and how much it costs to get divorced, equitable distribution, that's dividing assets. We'll talk about child support, alimony and spousal support, custody, parenting, and then a few miscellaneous areas such as prenuptials or modifications that are a little bit different. A lot of what times when I'm talking, it's directly related to divorce, but there's overlap, right? So sometimes if we're talking about custody or child support, the parents may never have been married and the same principles still apply. Okay, so let's talk about the different pathways. Now, this is definitely primarily, we're talking about divorce now, the different pathways, the different to take to get to the same destination. And that is the end of the end of the road, the end of the path is a court taking action and dissolving the marriage, granting a divorce, if you will. That's the end state. And then there's different pathways to get there. So that's what we're talking about. Throughout this discussion today, if you hear me talk about what a court might do or what courts do, it doesn't necessarily mean that every case gets to that point where a court decides or a judge decides. It's just that what courts do give us lawyers in this arena context in terms of what the judicial norms are, and that informs us for how we advise our clients and how we compromise and make settlements and the like. Okay, so to get divorced, okay, the traditional litigation model is just like you see in the movies or read about in the newspapers and television shows, and that is one party hires a lawyer, and the lawyer, he or she, prepares the divorce papers, which is a complaint, and gets a marshal to serve the papers. It's usually not as much drama as you see in TV and the movies where it's done in public. It's usually, it has to be served. So a marshal will typically, the person typically knows it's coming. The marshal will text them, say, hey, can we meet somewhere? Or they can just drop it off at where the person lives in abode, form of delivery. So that's how the process starts. And then the other side would conceivably hire an attorney, and then you go through the attorneys to negotiate and, if necessary, litigate. That's the litigation model. Each party has an attorney, and you go through the attorneys and to get to the end state. Doesn't mean there's going to be a trial. It doesn't even mean there's going to be litigation. 95% of the time, there's not going to be a trial in the litigation model. Sometimes a little bit higher percentage, there may be some court involvement, some litigation, but oftentimes we do cases where it's in the litigation model and we never step foot in the court, not once. We file things with the court to keep them updated on what we're doing, and we never go. Now, that's a little unusual. Most of the cases that are non-litigious in the litigation model require you to go to court early on for something called a resolution plan date, just to tell the court whether we think it's going to be a very litigious case or they're ready to go to judgment right away, and or something in the middle. And that's really for the court's planning, planning their docket for their informational purposes. It doesn't serve much utility for the clients, except that sometimes we can hammer out some temporary agreements and the like. So litigation model, everybody has an attorney. Another model to get to the same end state is mediation. And hopefully, if any of you are looking into divorce, you will consider the mediation model. In the mediation model, and you see two types there, and I'll talk about each. The most prominent one when people are talking about mediation is the couple hires a mediator who serves as a neutral. And they may also hire attorneys that are called review counsel, but those attorneys don't come with them to the mediation. The parties are representing themselves, and they have these attorneys in the background who can give them advice as to what they should be asking, what they should be looking for, and then later on that attorney will look through the paperwork or the settlement agreement through their client's point of view and provide some input and the like to kind of help the clients, but the clients are representing themselves, and the mediator serves as a neutral and doesn't provide specific legal advice, but moves both the clients along, helps communication, make sure that the I's are dotted, the T's are crossed, and everything that needs to be agreed upon is agreed upon, and then ultimately is memorialized in a comprehensive agreements and the like. That's the most common type of mediation. When people use the word mediation, that's typically what they're talking about. There's another type that has the same name. I wish we came up with a different name. Sometimes in the business we call it judicial mediation. And what that means is you started off in the litigation model. You each had attorneys representing you. You tried to negotiate, but you couldn't solve it. You couldn't reach it. You couldn't find a way to find compromises to solve it yourself. So you then hire a mediator, typically a retired judge. There's about 5, 6, actually a growing number, maybe 7 or 8 retired judges now that have about 90% of the market share. And you pay them for half a day, or in some cases a full day, if it's a particularly complex case. And that objective voice can help bring a settlement, really under the litigation model, but with the help of a judicial mediator. So those are the 2 types of mediation. There's something else that if you doing any research online or you have friends, you might have heard about something called collaborative divorce. That is a third model, and it's a bit of a hybrid. If you think about mediation, it's non-adversarial. At the end of the mediation, you have to get the court to sign off on it, but the whole time you're never going to court, right? In a litigation model, you may be going to court. The collaborative process is kind of a hybrid, in that meaning that you have attorneys who can help you every step of the way, like litigation. But it's also non-adversarial, like mediation, because you sign an agreement that you're so committed to the collaborative process that you agree that if the process breaks down and doesn't work, because either one party or both exit it, that none of the attorneys can continue to represent them. It's a little bit of a stick, carrots and sticks to keep people involved in the process. The collaborative model, each of the attorneys have to be trained in collaborative divorce, of which I am, as well as other attorneys in my practice. And because you use a slightly different language, we don't talk about people taking positions. We talk about trying to find interests and find what somebody's interests are and what theirs are, and they're different, get all the points of view on the table without people taking hard positions and the like, and discussing them to try to find solutions. There's usually, almost always, at least one other neutral involved. Oftentimes 2 other neutrals involved. So the 2 clients and the 2 collaboratively trained attorneys, right? Another neutral will be a financial neutral. And oftentimes an additional other neutral will be a mental health professional. Often, but not always, that mental health professional is when the couple has young children and their primary purpose is to work with the couple to work on a parenting plan and talk about co-parenting children after divorce, what the expectations are, what the needs are, and they work together to pull together a parenting plan. And like, that's usually what the mental health professional neutral is involved with. Sometimes we have a mental health neutral involved even when there is no kids, for various reasons. Sometimes mental health, substance abuse, and the like can be helpful to the process. The financial neutral is often either a certified divorce financial analyst or a CPA that has some particular training in the finances associated with divorce. And they help moderate and take a neutral point of view in terms of gathering all the data that needs to be collected for divvying up an estate and producing the financial affidavits and the like. So that's what a certified divorce financial analyst does. That's the collaborative process. There's pros and cons to each. I'd say litigation has the biggest market share of cases, mediation next, and then collaborative has a much smaller market share. I would suggest that for couples where it works, I think mediation is the superior model. I just strongly favor non-adversarial when it comes to families trying to avoid litigation. But mediation is not for everybody. Sometimes one or both spouses really feels like they need an attorney by their side, either because they need it to help stand up to the other side, they feel like they might be intimidated just from a personality standpoint, or the other side has a particular command of the family finances as compared to the other, so they really they need an attorney, frankly. And so sometimes we have discussions that I'm always listening for, would mediation make sense or not? And sometimes I'm just like, no, it won't. But most of the time I would like to see them try mediation, but it's not for everybody. And then collaborative can be for most cases. Occasionally we'll identify some cases where one or both of the parties are just their makeup is that they wouldn't stay committed to the process, in which case it's just better to go litigation, unfortunately. Okay, and litigation can also be non-adversarial if you get the right attorneys involved and the right approach and the like. So the pros and cons to each just depends on a couple's idiosyncrasies and like. All right, people always want to know, how much is it going to cost to divorce and how long is it going to take? How long it's going to take, I tell people to plan on about 9 months. There's some easy cases we can do with people don't own a house. It's a short-term marriage. They don't really have much to divide, no kids. We can do those in under 90 days occasionally. But by and large, I tell people to plan on about 9 months. In some cases, take a year. If people actually do have a trial, that takes a year and a half typically. But usually about 9 months, people plan on that. Sometimes a little closer to 6, sometimes closer to 12. How much is it going to cost? I'll give you a lawyer answer. It depends, but I'll give you a little more information. So it always depends on time, right? And so, and a lot of that's driven, if you see down here, the right side of the brain, the left being the logical side of the brain and the right being the emotional side of the brain. And, the law in this area is pretty simple. Frankly, there's several statutes that lays out what the law is. There's some case law, and most of the time that has applied it, usually the logic is easy part to solve. And there's some little bit of gray area negotiation and compromise to be had and the like. But as you can imagine, emotions run high during this time frame. It's just a tough time of life. And it's a struggle. And so that can often require more involvement of the lawyers. We try not to be psychologists. We try to get our clients, in the hands of psychologists and other therapists to help them through the mental part of it all. Divorce coaches as well. But oftentimes, we're the person that our clients need to lean on. And so some cases are just more involved and more intense in that regard. And that just drives the cost, because we all bill by the hour, hourly rates. And so the more time you spend, the more it costs. The type matters as well. So if litigation is kind of the baseline, mediation's about 40, on average, about 40% less than what litigation is. Okay. And then collaborative is about the same as litigation. You have these additional timekeepers, right? The financial analyst and the mental health coach that can add costs to it, no question. But there's also some cost savings involved with it as well, because the certified divorce financial analyst is doing a lot of stuff that the lawyers might otherwise do, or their staff or their paralegals would do, and they could do it more efficiently for both parties, as opposed to having two different paralegals and attorneys doing it. So there's some cost savings. Some people tell you it's a little bit less than litigation. I would say most people tell you it's a little bit more in litigation, but it's about the same, to be honest with you, collaborative. Okay, I know what you're saying. Okay, how much? I've read publications, but I've read a study, but I read this study 10 years ago, and it hasn't been updated, that on average in Connecticut, each side spends about $15,500 on their attorneys for a divorce in Connecticut. That's dated. I can tell you that there's lots of cases that I see where each side spends about $5,000. I see, we run averages and the like, and I talk to colleagues. I think if you looked at all the averages really, or a median, I would say it's more like 20 to 25,000 in this part of the state, $25,000-$30,000 Fairfield County. And there's many cases north of that, and there's many cases south of that. So anyway, that's some information. Our practice has some low-cost alternatives. Well, mediation is a low-cost alternative, right? I already told you that's 40% less than litigation. And there's some other attorneys that do this as well, and that is we can coach people or consult. We call it a consulting practice, where our clients will represent themselves but we help them every step of the way, or as many steps of the way that they want help. It could be ghost writing documents, telling them what motions should or shouldn't be filed or how to respond to a motion, ghost writing those, and just steering the ship along the way, but we don't actually go to court. But we can help them along the way. Sometimes we're involved in a case and it's a litigation case, and we're involved in it for a while and it turns just more muddy than expected, and the clients are running low on funds. They just can't afford to exhaust that much more of their family money and income and estate on lawyers. So then they shift to representing themselves, and by then they've gotten a little taste of it, gone to court. That's the type of case where they kind of can visualize some things, and then we can consult with them and coach them the rest of the way. Other people start off with consulting and coaching and then shift to litigation later. And then sometimes people do consulting coaching all along. Sometimes people don't do any of that all along. It's just a low cost alternative. I just want to make you aware of it, that may be out there. Okay. Equitable distribution. We're still talking primarily, well, we are still talking about divorce with this topic in terms of dividing property. Who's going to get what? Some states are community property states, others are common law states. Connecticut's an equitable distribution state, which is a bunch of legalese that just says there's a statute which is laid out right here in summary form. Dear trial judge, if this comes before you and the parties don't agree, this is the factors you need to consider when deciding how to divide the property. That is the length of the marriage, the causes of the breakup of the marriage, the age and health of the parties, station of the parties, and occupations, vocational skills, employability, and income of the parties, the estates of the parties, the liabilities and needs of the parties, opportunity for future acquisition of assets and income, and the contribution of each party to the acquisition, preservation, and appreciation of assets. Now, judges don't have to give any more weight to any one factor to another. They don't have to explain in their decision which factors they consider. They just in their decision, they just say, I considered all the equitable factors set forth in Connecticut General Statute 46B81, and they're covered. Then they can decide and do whatever they want, basically, when they divide the property, and they'll have a presumption that it was done correctly when the appellate courts are looking at it. In practice, while all the property is on the table, that includes property that was brought to the marriage, acquired before the marriage, all the property acquired during the marriage, anything that might have been inherited, all that needs to be disclosed and gets on the table, but it doesn't mean that's all going to be divided 50-50. Oftentimes the court will carve out those inheritances or carve out some premarital values. Sometimes it depends whether things have been commingled or not, but oftentimes those will be carved out. You get all the starting proposition for most of the marriages that are 5 years or more is that the court's going to look at what was acquired during the marriage and divide that 50-50, the assets and the debts. It's kind of a starting proposition for most of the cases. I say why 5 years or longer. Nothing in the law says that. Just in practice, some shorter term marriages under 5 years, a lot of time courts will just try to return the parties to the way they were at the date of the marriage. The longer the marriage, the stronger the presumption is that more and more stuff will be divided 50-50. Doesn't mean that each asset or each debt will be divided 50-50. But when you put it all on the table and after come up with a way to divide it, it's darn close to 50-50. So that's equitable distribution and division of property, and that's assets and debts. Personal property, courts don't really get involved with. Usually the judges really don't like to get involved in who gets the TV and who gets the couch and the love seat. And lawyers, we try not to get too involved in it. We try to leave, kind of like force the parties to be adults and figure it out. They can't always, and sometimes the lawyers will get involved and we'll, negotiate on that as well. Typically, more often than not, like 90% of the time, parties will figure out, a lot of times with some help with the lawyers, how to divide the personal property and who gets what. And then there's typically a clause in the agreement that says, all right, the parties have agreed to divide all their assets, yada, yada, but if they haven't divided it and if anything arises after this date, the parties agree to submit to binding arbitration. And what that means is that each side would share the cost of an arbitration, and of which, the arbitration officer would cost maybe $3,000, $1,500, kind of depends on how much is in the estate. They'd share that cost. They come in typically by themselves, sometimes with an attorney. They just pitch why they believe they should get this and the other party should get that. Then the arbitrator listens to both sides, makes a decision, that's binding. And that's how personal property is dealt with. But again, most of the time it's resolved through negotiation. All right. Child support, and this goes beyond divorce, right? So this could apply whether parties are getting divorced and have young children, it's applicable, or if they've never been married and they share children, then it's applicable. Child support is pretty objective in Connecticut and most states, frankly, and it's governed by child support. There's a child support statute that implements the child support guidelines. And then there's a family law software program that all the courts and practitioners use that implements the child support guidelines. And so you start off, but with the software, you just put in, all right, what's mom's income, what's dad's income, gross income. It'll automatically take out the deductions that should come out because, for example, if somebody's max savings on 401ks, that's reducing their net income. Well, this software is not going to allow that to happen. Just takes out taxes and FICA and like mandatory deductions, union fees, and a few other things that the statute permits, and then comes out the net incomes for each. And then the guidelines through academic studies, if a family of four, a mom and dad and two kids makes this income per year, then on average in Connecticut, they will spend this much on a child per week. And then based on the percentage of the incomes, the higher income earner will pay to the lower income earner X amount of dollars, which is a presumptive amount. Who has primary residence, we'll talk a little bit more custody here in a minute. That can make a big difference on who's paying who child support. But it starts off with just plugging in numbers from financial affidavits, and which are based off of tax records and W-2s and pay stubs, and the number of children, and outcomes a presumptive number. It's very objective. The statute says the court has to order that number unless it makes other findings. There is deviation criteria that us practitioners in negotiation often use and rely on to deviate a little bit from what the presumptive amount is. Sometimes even when parties don't agree, if it goes to a judge or a court, they'll decide, to deviate. Typically not a lot, sometimes a little bit. Some of the factors that which justify deviation include somebody might have significant assets. For example, maybe they're retired, but they don't have any income to put on the guidelines, to do the guideline calculation. Their income is much lower, but they have a lot of assets. Or there's a lot of costs involved. They may have other children or other costs involved that that's not reflected on the financial affidavits and through the software. Sometimes, for example, if there's one party lives out of state, then they need to spend a lot of money to exercise their parenting time. That's another reason why the court would deviate from that parent that has to travel to paying the otherwise presumptive amount. Okay, child support typically lasts until a child turns 18. If a child turns 18 during high school, then it continues until they graduate high school. And then the statute just says, look, it goes until the child graduates high school or turns 19, whichever occurs first. That's in Connecticut. Other states, child support goes to 21, but Connecticut goes to 18 or graduating from high school. Enforcement. Well, it starts off with you have to get an order in place before you can even get enforcement. And to get an order in place, you can either, if low income individuals can often go through the Department of Social Services, and who can coordinate with child support enforcement, and they can assist and get involved to establish an initial child support order. Other times people represent themselves, and then other times people hire attorneys. In any event, requires getting the documents that are needed to figure out, the incomes and the like, and to get that presumptive amount and to get an order in place. And then after that, enforcing it, if the payor is a W-2 employee, it's often, and you send the court order to the employers have to implement a wage garnishment and pay it directly to the mom or dad, whatever the case may be, the receiving recipient. So wage garnishment's fairly common for W-2 employees. And then if they don't have a W-2, they're not a W-2 employee, or otherwise not paying child support, you can then bring an enforcement action in terms of filing a motion, contempt motion, and move forward with that, typically with the lawyer, not always with the lawyer. That's how you can enforce child support. And again, sometimes for some people, lower income, child support enforcement will get involved as well. Modifying child support is always modifiable, meaning if somebody's, after the initial calculations are done and there's a presumptive amount in a court order establishing child support, say for $200 a week, and a couple of years goes by, or it doesn't matter the amount of time, and the person loses their job or their incomes change, or they get a big promotion, okay, some substantial change in circumstances, okay, warrants getting a modification to change the child support up or down, but you have to come to court to do that, file a motion to modify, and then present evidence that shows a substantial change in circumstances. Typically, if it would change objectively, if it would change the order by more than 15%, then that would be a substantial change in circumstances. Okay, college is different. So as we talked about child support ending when the child graduates high school. With respect to college, child support doesn't keep going, but there is a statute in Connecticut, 46B 56C, where if at the time of divorce or at the time an initial custody order was implemented, if the parents were never divorced, if a judge at that time made a finding that had the family stayed intact, it would have been more likely than not that they would have provided some post-secondary education for college, for example. Then a court retains jurisdiction to look at the financial circumstances at the time the child goes to college, or children, and then enter orders as to what share should be paid by each parent. So for example, the time of divorce, the children may only be 10 years old, or a child may be 10 and 12. The court doesn't decide at that time that mom's going to pay 40% and dad's going to pay 60%. It just enters an order that it cites the statute and retains jurisdiction. So when those children get to 18 and they're applying to college, if the parties can't agree on how to share it, then the court has jurisdiction to look at the financial circumstances, say mom's paying this, dad's paying that, up to a cap of what it costs to go to UConn. Doesn't cost, so court can't order anybody to pay over their share of what it would cost over and above to go to UConn. Doesn't mean they have to go to UConn, it just means that's what the jurisdiction of the court has in terms of ordering how much money somebody might pay. All right. Spousal support, otherwise called alimony, again covered by a statute in Connecticut. It's largely the same exact factors that we talked about a minute ago with respect to equitable distribution. A couple minor differences, but for the most part, it's the same factors the court's looking at. One of the things here at the end, for example, is difference that the last one listed there, the desire of the custodial parent to secure employment, or whether if they have a record of being the primary parent, just homemaker, do they want to stay in that role for a period of time, or whether it makes sense to, or do they want to get employment? So that's one of the factors. Doesn't mean they get to unilaterally decide, but it's a factor for court to consider. Alimony is a little much more subjective than child support. That's why I started with child support, because child support, we talked about how objective, at least the presumptive number is. Alimony and spousal support, I don't want to say it's the Wild West. It's definitely not, because there's definitely judicial norms and forum attorneys and the like of what's reasonable, what's not reasonable. Let me start by saying alimony is not in every case. And it's the common case, and give me an example, the most common one, it is prevalent, is if the parents had children and one of the spouses stayed home and was devoted to raising the children for a period, several years, period of time, while the other spouse was moving ahead with their career. And the children are still minors, below the age 18 at the time of divorce. That's an alimony case. Doesn't always have to be with children, though. It can be no children at all, and one spouse just makes a lot more than the other spouse. That can also be an alimony case. Maybe different and just how that is, what that is, and how long it is, what is different, and just depends on the facts and circumstances, and it changes over time. That is, judicial norms change over time. So there used to be, well, we still kind of start off in cases like where a spouse was staying home with the children for many years, and it's a longer term marriage, 15 years, 20-year marriage, for example. There's a presumption that alimony, the duration of it will be about half the length of marriage. I said there's a presumption. That's kind of there is no actual legal presumption. There used to be attorneys just used to start off with that premise, let me put it that way. And oftentimes when we met with judges for pretrials, we would start off with this premise. That's less the case now, but it's still kind of some information in terms of duration as a starting principle about half the length of marriage. Could be less, could be more, if it's an alimony case. Okay. And then again, how much? Well, that is definitely not objective. And it can take all types of shapes and sizes depending on the case. Sometimes it needs, if some spouse has been out of the workforce, maybe they need a lot up front for a short period of time, and to give them a runway, he or she a runway to kind of get a job or to finish school, and then maybe it's less amount later. And then other cases, you can, well, let me give you an example. If there's children, then there's also a child support order. We figured out that objective amount, and one of the spouses has been home with the child for many years, and then there's going to be alimony on top of that child support. It's common where that might be a case where child support and alimony together would get the parties to 50-50 for a period of time, for example, until the children are out of the nest. Not always 50-50. Sometimes the payor one will stay at about 60%, and we'll get, with child support and alimony together, or get the payee up to about 40%. Okay, typically not less than that, and typically not more than 50%, right? So that's kind of the lateral limits with respect to alimony, and that's with kids and child support, right? So if there's no kids, it's typically not going to get 50-50 unless it's for a super short period of time for a reason. Okay. All right, so that's kind of it as a general overview with respect to spousal support, custody and parenting. And this can be with divorce, without divorce, right? Maybe the parents were married, maybe they weren't. All right, so there's legal custody and physical custody. Legal custody starts off with a legal presumption that it's going to be joint legal custody. That doesn't mean how much that the parents are going to share the children 50% of the time. That's physical custody. We'll talk about in a second. Legal custody has to do with the major decisions that come about with the child's life, and the presumption in 95% of the time is that it's joint legal custody, that mom's opinion and point of view and dad's opinion and point of view have equal weight on those major life decisions, non-routine life decisions, such as what religion, if any, a child or children can be exposed to, decisions with respect to education. Sometimes there's, with respect, sometimes there's special needs requirements that need to be met. God forbid, there's certain healthcare, sometimes even more routine healthcare things, such as orthodontics and braces and the like. Those are a little bit more major decisions. Mom and dad have equal say. That's joint legal custody 95% of the time. Physical custody, sometimes it's more and more prevalent that it is 50-50 now, but it doesn't mean it's the most prevalent. I would say it's less than 50% of the time, but it is more and more prevalent than it was 20 years ago. So typically, one party is going to be the primary custodial parent, and the other person is going to have liberal visitation, to be defined. And it just depends. And what you look at is what's best for the kids. And it really depends on what the schedules are for the parents and their abilities to take care of the children. So if one spouse travels all the time for work, it doesn't necessarily, and would be having to hire somebody to help them, and the other spouse doesn't travel at all, well, it doesn't really make sense to do a pure 50-50 shared parenting plan, right? But in other cases, it does. And then for those cases where it is going to be a truly 50-50 shared parenting plan, it's usually not 1 week here, 1 week there, unless they're like late teenagers. For younger kids, it's usually, there's a couple different variations, but for a 225 or 252, meaning, here's an example. Monday, Tuesday, mom, Wednesday, Thursday, dad, Friday, Saturday, Sunday, mom. Okay, that's 2, and then 3. And then the next week, it'll start off with Monday, Tuesday, dad, Wednesday, Thursday, mom, and then dad's weekend, Friday, Saturday, Sunday. Another scenario is mom always has Monday, Tuesday, dad always has Wednesday, Thursday, and then alternate weekends. And there's different variations from there. Sometimes people that have to travel a lot, they can make a longer weekend. So when it's their weekend, instead it can include all of a Friday and maybe start on a Thursday overnight, or starts after school Friday and goes to Monday morning, and then there's opportunities to do an overnight or dinner during the week. So all types of permutations. Just depends what's best for the kids to have a strong relationship with each parent and the like. So I kind of covered physical custody and parenting plans there. Modifying, they're also modifiable. So if you come up with a great plan that makes sense, we generally suggest look at it every 3 years, because children just have different requirements at different ages. And they're, as friends get more and more important as they get to middle school and high school and the like. And then it's a whole different battle with teenagers. So anyway, things can be modified, typically by agreement. Sometimes modifications come through litigation. I can tell you that custody litigation is by far the most expensive thing that we experience. Thankfully, it's not a lot of it, but when it happens, it's tens of thousands of dollars if you're going to hire an attorney. And it's not good for children. We try to avoid it at all costs if possible. But sometimes we're not, it's our clients, their life, their decisions. So we can guide them and give them advice. And sometimes, the other parent is such that we really got to go to court and fight to protect the children, because it really is in their best interest. But litigation in custody can be super expensive. So is there any alternatives? Yeah, we try to say, okay, well, even when there's some toxicity and we still try to send people to like a co-parenting counselor or a therapist where they can just get things off their chest, be heard, listen to the other side, express some things, and then finally find some middle ground. We try that for sure ahead of time, and that is certainly less expensive and much more beneficial to all involved. Okay, relocation I mentioned in there. Oftentimes, if people want to move more than if they want to move 30 miles away, that could really impact, and take the children with them as the primary resident, that could really impact their relationship with the other parents. So they oftentimes, if it's particularly if it'd be out of state, you'd have to get permission from the court if it was going to be out of state. Sometimes in our divorce agreements, we say if either parent plans on moving more than 15 miles or 20 miles or 25 miles from the current marital residence, then they have to either agree or get permission from the court. If sometimes somebody needs to move for a job, you got to go to court. Those are the toughest cases judges have. They hate them. The person who's prospectively wants to relocate has the burden, and they have to show that they're moving for a justifiable reason. And then the court will look also what's in the best interest of the children. But it's definitely not a foregone conclusion that the children will go with whatever parent wants to relocate, but it does happen sometimes. All right, some miscellaneous topics, and then we'll see if there's any questions. People ask about legal separation versus divorce. They often think of it like, maybe I can just stick my toes in the water as opposed to jumping in, and maybe that's legal separation be the way to do that. So what I would suggest or would be that when it comes to sticking your toes in the water, you're really not talking about legal separation. It's really something more informal, and that is you just decide, hey, let's just take a break. Maybe one spouse moves out or the other spouse moves out. We take a break and just see how things go. Maybe we meet with a counselor or therapist or not. That's certainly possible. That's not a legal separation. If you want to get a legal separation, you can, it requires all the same steps as a divorce. And typically it's going to include lawyers as well. And we'd be doing the same things. We'd be gathering the same financial documents, bank statements, tax records, credit card statements. valuations for homes, valuations for cars, and the like. We're gathering all the same stuff in divorce. We still have to produce that financial affidavit, just like we do in a divorce, which is the most important document that courts rely on for divorces and legal separations. Not with respect to custody, obviously, but on finances, they really rely on them. So a lot of diligence goes into these, preparing these financial affidavits and looking at the source documents that provides the information that's in them. All those things are still required in a legal separation. Then the negotiation is the same to come up with a settlement agreement. And then the settlement agreement's comprehensive, just like in a divorce. The difference is at the end, when you submit it to the court, you're just saying, dear judge, don't dissolve the marriage, just make it a legal separation. And then all the terms are there. And then if either party wants to convert it to a divorce, it's really a form you submit to the court, and you can convert it to divorce, at any time. So there's really no cost savings or time savings involved with legal separations compared to divorce. One of the things historically, it was more popular 10 to 20 years ago and the like, because it allowed one parent to stay on the other parent's health insurance. And as everybody knows, health insurance is very expensive. If one employer, the spouse has an employer that's covering all of it or 80% of it, and then you get divorced, the other spouse is going to be on their own. If they could stay legally separated, sometimes they could do everything, and then for a period of a few years or 5 years, they're legally separated, they stay on the health insurance of their spouse, and then at an appropriate time, they just convert it to divorce down the road. Insurance companies got wind of that many years ago, and most of the time, most of the time, they have it written in that even a legal separation would essentially kick the other party off. There is something called COBRA that you probably heard about that entitles somebody to keep insurance, but they would still have to pay the full premium or cost. So legal separations aren't as popular. The other reason is since the Affordable Care Act, Obamacare, at least in Connecticut, I don't know how other states have implemented or has changed over time, but you can go into the exchange, a spouse can, and often get fairly decent and affordable healthcare, certainly less than it would cost to COBRA it. Depends how old you are and the like, depends if kids are involved, it depends on your health, et cetera, but it's much more affordable and accessible than it used to be 10 years ago. All right, so that's legal separation versus divorce. Prenuptial agreements, I think you probably heard of what those are, right? Before you get married, you enter an agreement that lays out what the terms are in the event that a divorce comes later. They're more popular nowadays than they used to be. One of the reasons for that is because gray divorce or silver divorce is more popular than it used to be. What I mean by that is those age 50 and older, the divorce rates in the last decade have climbed and continue to climb, whereas divorce rates below age 50 have decreased during that same period of time. So gray divorce, oftentimes the parties before they get married or they've been divorced and they were going to remarry as gray or silver remarriages, and they already have families from before, children, and they just want to kind of keep their finances separate. So prenuptial agreements are popular in that context. So it's not just for the super wealthy. In other times, people just make sense for whatever reason, sometimes cultural reasons. So prenuptial agreements are more popular than they were a long time ago. But they require lead time. A lot of time, too often we get calls like 2 weeks before the wedding, and people want to get a prenuptial agreement. We can't help them, and I don't know any lawyer that can, frankly, because it doesn't require the same diligence as a divorce, but it does require disclosures to be made and financial affidavits to be prepared. And of course, the agreement itself to be negotiated and agreed upon, memorialized, signed off on, and the like. So we typically tell folks we need 3 or 4 months lead time. If somebody called us 2 months ahead of time and somebody else had another attorney that had already been preparing the documents and the like, yeah, we could probably get involved at that point. But 3 to 4 months lead time before a wedding is what's advisable, so that each party is going to need representation in order to make it binding later. Postnuptial agreements. Sometimes people, after they get married, want to enter into a postnuptial, like a after marriage prenuptial, if you will. it's basically a prenuptial. They just do it after they got married. So it's not, they don't think they're going to get divorced, but just in case, they prepare a postnuptial agreement. We don't do them because they're not as enforceable in Connecticut. We shy away from them. There are lots of attorneys that will do postnuptial agreements. We just don't, with the law on their enforceability isn't as strong, so we just kind of shy away from them just as a business decision. We do lots of prenuptials, and they're very binding. Especially, there's been a trend in cases last 2 years coming out of the appellate courts in Connecticut that where people oftentimes try to get out of them will try to litigate and say they were unreasonable at the time, and there's some pretty unreasonable clauses that the appellate courts are upholding. So they're very enforceable. Prenups, postnups, not as much. We stay away. Sometimes people get a fair amount of calls for grandparents wanting to have rights because there's some, obviously the relationship with the parent, whether it's their child or the in-law or step. I don't even know if I got it right, but anyway, their in-law, the other parent, their relationship's not good, and they want to have rights. They want to see their grandchild. Connecticut's tough law in this area. And it really, by tough from the grandparents' point of view, it really empowers the parent. So we usually will go over the law with grandparents that are calling about it to help them understand it, but there's very little we can do, and usually the decision's made not to litigate, but at least they have an understanding. And if things change factually, maybe they can pursue it later. And we give them some advice and some things that can help them in their particular matter. All situations are different, obviously, different relationships. And sometimes we might get involved a little bit, but it wouldn't be litigious. Usually wouldn't be litigious. The exceptions to that is there's a case that come out this year that has carved away a little bit of that law, meaning in this particular case, it was an aunt actually who had forged, and the father had been out of the child's life for many years, except for occasional visitation. And then the mother died and the grandmother died, and then the aunt had been for a period of time taking care of this child and had formed that true parent relationship. So if those facts are where a grandparent or an aunt or uncle, third party, has truly over time forged the type of relationship that you typically think of mom or dad, then they have a leg to stand on as it comes to some other parent who is really not in the child's life. Then there may be some wiggle room in those circumstances, but otherwise it's a tough road to go. All right, so questions. Happy to answer any questions. Rachel, should I close down this so I can read them, or you want to read them?
Well, no, I can read them because I
Read them?
like that you have the contact info up there. So maybe that might give people a minute to write that down. I guess what I wanted to make sure we covered all options for cost savings. I know you mentioned mediation. I know you mentioned the coaching piece. Are there any other resources that people might be able to take advantage, or payment plan information type of thing if they're really struggling but not in a situation where they can stay with that person?
Yeah. Good question. For some low income households, I can't remember if it's for divorce or not. There's in Hartford there is a resource, and I'm sorry I don't have the contact information with us, but if you contacted us, we'd point you in this direction. And then every courthouse has a court service center in it. So I know not everybody's necessarily from Bloomfield, but Bloomfield's in the Hartford area. So the Hartford address courthouse on Washington Street. Make sure you go to the family courthouse, because it's not the one with the big pillars across the street, and it's not the criminal building, but it's a smaller building, 90 Washington Street. But anyway, you go there and there's a court service center, and in there's professional employees. They're not lawyers, but they're there, and they are very knowledgeable to help people help themselves, if you will. So aside from just hiring us as consultants, every courthouse has a court service center. Some are better than others, but Hartford's a pretty good one. And they tell you what forms to fill out and how to get things served. They can give people phone numbers for marshals, and they're very helpful. It's a lot of, you know, it's a lot to do and to be sure, but they're super helpful. So that's also, that's for everybody, you know, can qualify for that. I don't, I would, you know, the Hartford Bar Association has a lawyer referral service. If you call that number, they may know whether there's any attorneys that would that might be more affordable or take payment plans and the like and work with attorneys. They might be knowledgeable of that. I don't really know of any that I would, and even if I did, I don't think it would be for me to recommend or give their names out here. I do think there are probably a few lawyers that will work that way, but not a lot. But maybe the Hartford Bar Association Lawyer Referral Service, or if anybody's in another part of the state, New Haven Bar Association has a lawyer referral service, so does New London County. Fairfield County, for some reason, doesn't. They used to, but they don't anymore. But oftentimes the New Haven lawyers can help out in that neck of the woods. Does that answer your question?
Yes, thank you. You know, always looking for resources.
Yeah.
So thank you, Paul. I'm going to stop the recording and see if anyone else has any questions.